So I wanted to talk about the California governor's pardon power. Both the United States president as well as California's governor have the power to pardon someone. The president's pardon power is contained in Article 2, Section 2, Clause 1 of the federal Constitution, and it provides the president shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. The California governor's pardon power is contained in Article 5, dealing with the executive branch, Section 8, Subdivision A in the state constitution. Now, the president's pardon power grants a criminal offender relief from any punishment from his or her conviction. The governor's pardon power is analogous in this state. Section 8A of Article 5 provides the governor with the power to grant reprieves, pardons, and commutations, except in the case of an impeachment, again, similar to the federal Constitution's limitation on the president's pardon power. This authority is discretionary because the governor's power is on conditions the governor deems proper. So the power to grant a reprieve, pardon, or commutation occurs after an offender is sentenced. And this power is also subject to application procedures that are provided by statute. As a result, the California legislature has imposed some procedures for applying, but granting a reprieve, pardon, or commutation is entirely in the discretion of the governor. And there's no role for the legislative branch of government in the actual granting. Nonetheless, our state constitution does require the governor to report to the legislature every reprieve, pardon, or commutation that the governor has granted. And in that report to the legislature, California's governor is required to state the pertinent facts and the reasons that he or she granted the reprieve, pardon, or commutation. Government Code Section 12017 specifically provides that at each session, the governor shall report to the legislature each reprieve, pardon, and commutation granted, stating the name of the convict, the crime of which he or she was convicted, the sentence, its date, the date of the pardon, reprieve, or commutation, and the reasons for granting the same. Note also that the California Secretary of State, pursuant to Government Code Section 12162, is required to keep an actual register and attest to these official acts of the governor, which includes pardons issued. Also, under Section 12030 of the California Government Code, the governor is required to keep a register which includes all applications for pardon or commutation of any sentence. Now, there is one constitutional limitation on the governor's pardon power. The governor may not grant a pardon or commutation to a person who has been twice convicted of a felony, except on the recommendation of a majority, which means 4 justices have to agree, a majority of the state Supreme Court. So California's High Court acts upon an application that's been submitted by California's governor, and the High Court usually approves these gubernatorial requests. But in the past couple of years, the state Supreme Court has in fact rejected a few of the applications by the governor. Under the governor's constitutional power to grant a reprieve, pardon, and commutation, a commutation is a reduction in punishment. A pardon is the remission of guilt and relief from the legal consequences of the crime. And a reprieve is a temporary suspension of executing the sentence. Now, as I mentioned earlier, the governor's clemency power is exclusive in California, and the legislature has no power to grant a reprieve, pardon, or commutation. Executive clemency is deemed to be ad hoc, an act of grace that may be granted for any reason without reference to any standards, and consistent with the California separation of powers principle contained in Article 3, Section 3 of the California Constitution. Pardon and commutation decisions have not traditionally been the business of the courts, and they're rarely, if ever, appropriate subjects for judicial review in the state of California. And that's referencing the Santos versus Brown California Appellate Court decision in 2015.